the chaos and destruction of war, there's a law that stands as a protector of the most vulnerable: International Humanitarian Law, or IHR. But what is international humanitarian law, and why is it crucial to global peace and human rights? International humanitarian law is a unique body of law developed to protect individuals who are not directly involved in fighting: civilians, prisoners of war, and the wounded. It's a powerful tool designed to limit the impact of war, ensuring that even in the darkest times, humanity still holds ground. Welcome to City Education, your home for knowledge in all forms, shapes, and sizes. International humanitarian law, also known as the law of armed conflict, is a body of rules that seeks to protect people who are not or are no longer participating in hostilities, and to regulate the means and methods of warfare. It is rooted in human dignity. International humanitarian law does not seek to prevent war entirely, but to limit the human suffering it causes. It recognizes that even in war, there are rules. This body of law primarily arises from the Geneva Conventions of 1949 and their additional protocols of 1977, as well as the Hague Regulations of 1907. It is also shaped by customary international law practices accepted as legally binding. In South Africa, international humanitarian law has been incorporated formally into domestic law through the implementation of the Geneva Conventions Act 8 of 2012. According to legal scholars like John Dugard, the essence of international humanitarian law is to provide protections in times of chaos, balancing military necessity and humanitarian concern. The International Court of Justice, as Judith Gardam explains,
plays a central,
though sometimes cautious, role in interpreting and in reinforcing these humanitarian principles. In this video, we'll explore the 6 foundational principles of international humanitarian law in line with John Dugard, and understand the role of the ICJ, as well as assess the realities of enforcement and compliance in our world today. Now, let's start off historical foundations and key instruments of international humanitarian law. The roots of international humanitarian law stretch back centuries, but the modern framework began to take shape in the mid-19th century. The first Geneva Convention of 1864 was initiated by Henry Dunant after witnessing the horrors of the Battle of Solferino. This convention was set up to protect wounded soldiers and medical personnel. Over time, the Geneva Conventions expanded to include protection for prisoners of war, civilians, and shipwrecked soldiers, which culminated in the 4 Geneva Conventions of 1949. These were further supplemented by additional Protocol 1 and 2 in 1977. Protocol 1 focuses on international armed conflicts, while Protocol 2 addresses non-international armed conflicts such as civil wars. John Dugard notes that while almost every state is a party to the 1949 conventions, some major states like the United States, Israel, and Pakistan have not ratified the additional protocols, which creates gaps in legal consensus. The ICJ has affirmed the universality and importance of these instruments, and according to Gardam, the court's interpretation has helped reinforce customary humanitarian norms even in politically sensitive contexts. Together, these instruments form the backbone of international humanitarian law, setting out both protective measures and responsibilities in times of conflict. Now let's look at the 6 core principles of international humanitarian law based on Dugard's categorization. These 6 principles guide how war is fought and how humanity is preserved in times of armed conflict. The first principle is one that addresses combatants and prisoners of war. According to this principle, international humanitarian law distinguishes clearly between combatants and civilians. Combatants are lawful participants in war, and if captured, must be treated as prisoners of war, not criminals. Duvay emphasizes that prisoners of war are not hostages or offenders, but are detained solely to prevent them from returning to the battlefield. In addition to this, the Third Geneva Convention of 1949 governs their humane treatment and obligates their repatriation after hostilities cease. However, challenges arise with irregular fighters, such as guerrilla groups and resistant movements. Article 44, subsection 3 of the Additional Protocol 1 allows for combatant status if certain conditions are met. Dugard critiques instances where states, such as the United States at Guantanamo Bay, failed to honor these rules, highlighting the risk of undermining international humanitarian protections. Let's move to the second principle. The second principle, according to Dugard, deals with occupation and the protection of orphans. The Fourth Geneva Convention
sets out
protections for civilians in occupied territories, prohibiting practices like torture, hostage-taking, forced deportation, and collective punishment. Dugard explains that an occupying power does not acquire sovereignty, and its primary duty is to administer the territory without altering its status and demographics. He points to Israel's occupation of Palestinian territories as a major area of dispute. Despite Israel's argument, the ICJ ruled in the 2004 Wall opinion that the Geneva Convention still applies. Dugard also identifies similar issues in Western Sahara, Northern Cyprus, and Gaza, where occupation persists despite legal contestation. Now let's move on to the next principle, the distinction and proportionality principle. The principles of distinction and proportionality are foundational. Distinction requires that combatants always distinguish between civilians and military targets. Attacks must be directed only to legitimate military objectives. Proportionality, on the other hand, prohibits attacks with civilian harm would outweigh the expected military advantage. Dugard further critiques modern warfare methods like drone strikes and targeted assassinations, which blur the lines and result in civilian casualties. The ICJ, as Gardam notes, has not always applied these principles rigorously, but it has recognized them as customary international law. Let's move to the focus of the next principle, which is international and non-international armed conflicts. Initially, international humanitarian law applied only to wars between states, but today, civil wars, insurgencies, and wars of national liberation also fall under the scope. Dugard highlights Common Article 3 of the 1949 Conventions, which sets minimum standards for humane treatment in internal conflicts. Additional Protocol 2 provides more detailed protections, but applies only when rebel forces control territory and conduct sustained operations. Gardam, on the other hand, praises the ICJ's role in bridging the divide between international and non-international conflicts, particularly through the endorsement of the Tadich decision, which defined armed conflict broadly. Principle 5 focuses on human rights and international humanitarian law. While distinct, human rights law and international humanitarian law often operate in parallel. They both aim to protect and preserve human dignity during war. In the All opinion, the ICJ ruled that both regimes apply simultaneously, especially when state exercises control over occupied territory. Gardam affirms this, arguing that the court's approach helps reinforce protections rather than limit them. Finally, the principle that focuses on enforcement of international humanitarian law. Now, a major weakness of international humanitarian law is enforcement. Although the Geneva Conventions and Protocol 1 oblige states to respect and ensure respect for international humanitarian law, violations are rarely prosecuted. The International Criminal Court and ad hoc tribunals, like those of the Rwanda and Yugoslavia, have made progress, but enforcement is still hindered by state politics and lack of political will. Gardam echoes this, noting that while the ICJ has helped shape the law, it has not always held violators accountable, which limits its deterrent effect. We all know that rules mean nothing without enforcement. That is why international humanitarian law includes accountability mechanisms for those who commit serious violations. These include war crimes, genocide, and crimes against humanity. States have the primary responsibility to investigate and prosecute breaches of international humanitarian law. But when they fail to do so, international mechanisms can step in. The International Criminal Court prosecutes individuals for war crimes under the Rome Statute. It is a permanent court with global reach. Ad hoc tribunals like the ICTY for the Yugoslavia and the ICTR for Rwanda played critical roles in developing international humanitarian law and international criminal law. For example, the ICTY affirmed that international humanitarian law applies in internal conflicts and not just international wars. This was a huge step forward. While the International Court of Justice does not prosecute individuals, it plays a vital role in shaping the interpretation of international humanitarian law. Through its advisory opinions in state-to-state cases, the ICJ clarifies state responsibilities and strengthens the legal framework for protecting civilians in conflict. Gardam notes that, although the ICJ's influence is often overshadowed by criminal courts, its contribution to clarifying customary law, evaluating humanitarian principles, and affirming state duties under the IHL is profound. While the International Criminal Court holds individuals accountable for war crimes, the International Court of Justice, or ICJ, plays a different but crucial role in developing and shaping the law of armed conflict. As Judith Gardam notes, the ICJ has made key contributions to the humanization of international law, a shift towards recognizing the central place of individual dignity and humanitarian values in the international humanitarian law. In Nicaragua versus United States, the ICJ confirmed that the Geneva Convention of 1949, particularly Article 3, formed part of customary international law. This ruling applied the core principles of international humanitarian law, like humane treatment and prohibition of torture, to internal armed conflicts. Gardam further notes that this case marked a turning point, recognizes that humanitarian protections apply even when states try to claim it's a purely domestic matter. In 1996, the ICJ issued an advisory opinion on whether nuclear weapons could ever be lawfully used. The court declared that international humanitarian law, especially the principles of distinction and unnecessary suffering, applies to all forms of warfare and all types of weapons, even those not yet invented. Gardam explains that the court identified two cardinal principles of international humanitarian law. The first principle was that civilians must never be the target, and weapons must be able to distinguish between civilian and military objects. The second principle is that combatants must not be subjected to unnecessary suffering. The ICJ declared these rules to be intransgressible, meaning no exceptions, no matter how severe years of conflict. In the Wall opinion, the ICJ reaffirmed that international humanitarian law and human rights law can operate together during armed conflict, especially in occupied territories. This reinforces the principle that people are protected not just in peacetime, but in times of war as well. Gardam emphasizes that the ICJ's jurisprudence has helped elevate Martin's Clause, which is a provision based on the laws of humanity and dictates public conscience, which gives a real meaning in legal interpretation. Although the ICJ doesn't punish war criminals, it sets the legal foundation and boundaries that govern how wars must be fought. International humanitarian law isn't only the concern of global powers and international courts. It is also alive within domestic systems, including here in South Africa. South Africa is a signatory to the 4 Geneva Conventions and their additional protocols, affirming its commitment to the protection of civilians, prisoners of war, and the wounded during armed conflict. Under the South African Constitution, international law plays a significant role. Section 39, subsection 1, paragraph B, states that courts must consider international law when interpreting the Bill of Rights, thus reinforces the importance of international humanitarian law in matters of human dignity, life, and justice. South Africa further contributes to regional and global peace through the development of its defense forces in peacemaking operations under the UN and AU. These missions are grounded in international humanitarian law principles, particularly the protection of civilians and minimization of force. South African legislation and military manuals further incorporate international humanitarian principles. Domestic courts increasingly reference international humanitarian norms, especially in cases involving extradition, universal jurisdiction, and state responsibility. As Dugard notes, South Africa's post-apartheid legal order is rooted in human dignity, equality, and the rule of law, values that mirror those at the heart of international humanitarian law. Through its legal system, diplomacy, and defense policy, South Africa contributes to a global order where even war is governed by conscience and law. International humanitarian law stands as one of humanity's greatest legal achievements, a shield for the defenseless, a restraint on the powerful. From the battlefield to the courtroom, international humanitarian law reminds the world that even in the most extreme circumstances, there are lines that must not be crossed. The International Court of Justice has played a pivotal role in affirming this truth, elevating principles of distinction, proportionality, and humanity into global standards. As Dugard and Gardam both show, international humanitarian law is no longer just about state interest. It's about individual dignity, universal values, and accountability. And that brings us to the end of this video. If you found this video helpful, don't forget to like, share, and subscribe. This is City Education, your home for knowledge in all forms, shapes, and sizes. We'll see you in the next video.